Good afternoon, everybody. Thank you for joining this webinar. I am Rukia Baruti, the Secretary General of the African Arbitration Association, or the APA in short. I'm pleased to be hosting and moderating this webinar. And I look forward to an engaging discussion. Can you hear me twice? Yeah?
Yeah.
Most would agree that something changed when the world saw that video showing the police officer's knee on George Floyd's neck. Now, it was a very hard video for most people to watch, and the act was so disturbing that it triggered global protest, shining a spotlight on institutional racism. This led to several firms and institutions issuing statements denouncing racism, sharing their plans on how to deal with racial diversity. Some law firms, big law firms in London and internationally, joined a Law Firm Antiracism Alliance, while other law firms in London joined a race and fairness commitment. Now, as far as arbitration is concerned, the International Council for Commercial Arbitration, or ICCA, announced its diversity and inclusion policy and implementation plan last month in June. Now, being a globally recognized international arbitration body, I think that ICCA is in a unique position to lead the way in dealing with underrepresentation in international arbitration of people of color, especially people of African descent. While the killing of George Floyd may have triggered a renewed call to end systemic racism, the need to be more inclusive in international arbitration was highlighted when Jay-Z, an African-American rapper, successfully halted an international arbitration he was party to for unconscious bias. Because only 2 out of over 200 arbitrators that were proposed by the American Arbitration Association were African American or identified as African American. Now, racial bias, conscious or not, has historically been a difficult topic to address, and many people are not comfortable doing so. But now, more than ever before, people are talking about it, and not only are they talking about it, they are willing to address it. For instance, 2 American arbitration practitioners, one white, the other African American, took it upon themselves to create a list of African American arbitrators. This list was expanded to include individuals of African descent. Could it be that the cumulative effect of all these events has led to a global awakening of some sort, like a global soul searching, so that people want to address this issue? On the panel, we have people who are going to be discussing and addressing these issues. We have Professor Gabrielle Kaufman-Koller. She's the immediate past president of ICCA. She's also a member of the ICCA Diversity and Inclusion Committee, which she founded under her presidency. And we have Professor Emmanuel Gaillard, who founded and has Sherman and Sterling's 100-lawyer international arbitration practice. We also have Professor Dr. Jacqueline van Hasselt van Hof, who is the Director General of the London Court of International Arbitration, or the LCIA. So we will begin with a 5-minute opening remarks by the President of AFA, Chief Bayo Ojo, SAN. I will then invite our panelists to answer questions that I put to them. This will be followed by a 5-minute comment from one of the attendees to give an African-American practitioner's perspective on racism. Panelists will then be invited to make any comments before I invite them to answer questions on the question and answer session towards the end. So Chief Bayo, you now have the floor and your 5 minutes starts now.
Thank you, Kia. Good morning, good afternoon, good evening, depending on what part of the world you are today. And thank you for joining us for the first in the series of webinars being put together by the African Arbitration Association. The African Arbitration Association, AFA, is a non-profit sector-led association that supports the continuing development of international arbitration in Africa. It aims to act as a platform for African international arbitration practitioners and African arbitration institutions to enhance their capacity, thereby advancing the use of international arbitration and alternative dispute resolution as an effective method of resolving African-related commercial transactions and disputes. Our membership is open to the whole world, not to Africans alone. The topic for today's webinar, Hitting the Core, Committing to Racial Diversity in International Arbitration, cannot be more apt, going by the recent developments all over the world, particularly in the US. Let me say thank you to all our eminent speakers who have found time within their busy schedules to join us today. We'll keep you posted on future events or webinars which we'll be hosting. So in the meantime, I want to invite you all to sit back and enjoy this webinar. Thank you very much. Thank you, Rukia.
I will now just start with the questions. Thank you, Chief Bayo. The first question is to Professor Gabriel. I understand that ICA's recently published Diversity and Inclusion Initiative was developed during your presidency. How does this initiative improve upon the implementation of ICA's previous practices on diversity?
Thanks, Rukia. Before I start, maybe I should say that I am very happy to be on this webinar. I would like to thank you, Chief Bayo, for the invitation, and also you, Rukia, as President and Secretary General of the of AFA. I have very fond memories, by the way, of a workshop at a congress in Kigali a little bit over 2 years ago, where I probably met many who attend this call today, and that was just shortly before the launch of AFA. So that is a nice is a very nice recollection for me. In 2012, the ICA underwent sweeping changes in its governance structure. It changed from a co-opted council to a membership organization. And on this, and since then, ICA has taken diversity into practice in all its operations, and that is in the composition of the governing board. This is in the constitution of panels for congresses, in the appointment to task forces and committees. That the difference of the new initiative, these were just practices. The difference, which by the way, we started working on these diversity policies more than 2 years ago, but it did take time to draft them, and first of all to understand what we wanted to do. Did we want to do some general guidelines, or do we want just to say what are we doing about it? And in the end, it appeared to us that the right thing to do, which also was more humble, was to say this is that is our commitment to diversity and inclusiveness. But then it took time to exactly identify what our commitment was and what we could effectively do. We, by the way, did this with the help of an independent consultant, Professor Spain Bradley, who is teaching in the US these topics and advising many organizations on these issues. Now, the policy that has been announced in June and was approved by the governing board in May makes the following differences. It does formalize the practice, and it consolidates, it reinforces the practices, it does formalize them in text. That to me has a symbolic virtue in the sense that it sets a signal towards the outside world and says this is what ICA is committed to do in terms of diversity. You can all read it on the ICA website. The elaboration also had the merit of raising the awareness internally within the organization that maybe we can do more. We can, in terms of diversity. And the same will hopefully happen with the ongoing process, because we're never done with diversity. We need to cultivate it as we go ahead. The practices also expanded the access of diversity that ICA takes into account, and the policy, if I can quote it, says, ICA affirmatively values the diverse ways by which people identify, inclusive of age, color, disability, ethnicity, gender, indigenous origin, nationality, national origin, race, religion, sexual orientation, and socioeconomic status. So it's a very broad understanding of diversity. Obviously, it does include regional and racial diversity. And another improvement of the present framework is accountability. That seemed important, to introduce some mechanism for accountability. The organization is will keep statistics, publish the statistics, be accountable to the board, be accountable to the members, be accountable to the public. And the last point that I would like to stress, there would be many more, but time is of course limited. The policy applies to ICA office holders and staff, but at the same time, there is an express expectation towards members and anyone who participates in ICA-sponsored activities to comply with the diversity inclusion values, and not only in ICA activities, but also in their professional endeavors generally. And that gives the framework of what we hope to achieve by having adopted these additional, these formal policies on diversity and inclusion. Rukia, I hope that is enough for the time being. Otherwise, I tend to speak too long, right?
Thank you. Thank you very much, Gabrielle. The next question is to Jackie. Jackie, arbitrators of African descent have expressed frustration that the only way they can get appointed by a renowned arbitration institution is by working in one of the big law firms or the big chambers, barristers' chambers, that is. To what extent is this perception accurate insofar as arbitrator appointments by the LCIA are concerned?
Thank you, Rukia, and thank you both, you and Chibayo, for hosting this event, which, as you explained in your introduction, comes at a very topical time. And I think we are genuinely at the cusp of a change in society in many ways, where it is incredibly sad that certain dire events have triggered a rethinking, but I think that there is now a rethinking. Another reason why, certainly for me personally and at the LCA, this is a very topical discussion, as I think many know, the LCA has been at the front of gender diversity for quite some time. And as challenging as that has been and remains, I have always said that to some extent that is low-hanging fruit. And I think the latest numbers have demonstrated that. I do not want to suggest at all that that is a mission that has been accomplished, but we have made great progress. And as I said last week, when I was delighted to accept the GAR award for this particular achievement, our work only begins, because diversity is incredibly diverse, and racial diversity, ethnic diversity, regional diversity is incredibly important. To now turn to your specific question, that is a challenging one, because it is interesting to me to the sentiment that you convey is indeed something that I hear about, but it is not something which is unique to arbitrators of African descent. And one of the things we need to do is to look at the facts and look at the numbers. And the first question really is, how are arbitrators selected in a particular institution? And if you look at the LCIA statistics, you can see that 50%, about half of the arbitrators, are selected by the parties and about half by the institution. The institutional selections tend to be the chairs and sole arbitrators, where we impose higher experience, more senior practitioners with prior experience. What I find interesting but slightly frustrating is that if you look at the number of African parties, there is a larger number of parties represented than the percentage of arbitrators coming from Africa. Now, an initial complication here is that the statistics that we currently have only tell us what the nationalities are. They do not give us further information about the profile of arbitrators. So we have started recording nationality. You see that in our national report. We do not currently report on race. And I guess there's a sort of assumption that if you equate nationality with race, you get a sense of the makeup of the arbitrators pool, but that's only a rough approximation. But what I find especially frustrating is if you look at the law that is being selected by parties to their contracts, there's a predominance of English law. So that on the one hand, the basis for some frustration, but equally it is part of the explanation why there is currently a predominance of a particular type of arbitrator, simply as a reflection of the law that is chosen. But I think we can all do better, not just institutions. I think parties can do better by, even if and when English law is chosen, to verify whether an English practitioner or somebody based in England is the best placed to deal with a dispute. And if you look at what the LCA itself does, as with other forms of diversity, we appoint proportionally more non-British arbitrators compared to the parties and the co-arbitrators. But that doesn't necessarily achieve the type of diversity and inclusiveness that we are aiming for. So I don't think it is fair to say that there is necessarily a practice of seeking arbitrators from big law firms or chambers only. Big law firms actually not at all, but that is for conflict reasons, not for profiling reasons. Chambers, yes, insofar as barristers, so insofar as English practitioners are concerned, there are a lot of barristers being appointed, but there is a reasonable amount of diversity nowadays in the candidates that we seek who come from chambers. But we are increasingly seeing independent arbitrators popping up, if you will, and certainly being selected. If anything, that's for us a very attractive pool because of their neutrality, which is harder to achieve sometimes than with large firms or even chambers. So I see that there is a basis for frustration, but that's a frustration which is shared with many people who say, why don't we have more French arbitrators being appointed? Why don't we have more Latin American arbitrators appointed? So I think we all need to do better at looking at what is the profile that is genuinely most appropriate for the case in question. I hope that's the beginning of an answer of what will be, I think, a broader discussion.
Thank you, Jackie, for that. My next question is to Professor Emmanuel. The diversity data shows that there are fewer lawyers of African descent retained as associates in Magic Circle law firms, such as Sherman and Sterling, than any other racial group. The fact that less than 1% of partners in Magic Circle law firms are of African descent implies that there's a pipeline problem. What inclusive strategy is your firm adopting to tackle this?
Thank you, Rukia, and thank you, Chief Bayo, for inviting me. I'm delighted to participate in this webinar for this cause, which I have to say are very much at heart. And to answer your question, the first aspect of the answer is, where do we stand at Sherman and Sterling? And the answer is, there is still a lot to be done. And we do have 3 Black partners, which is 2.2% of the US partners. I have the statistics regarding US partners and US associates because it's hard to track this kind of information elsewhere due to a number of privacy laws, and for good reasons. There is a debate, should we track that, should we care at all about it? Personally, I think that it's a good policy to track, because awareness is the first step. You have to know where you are if you want to improve. And I completely agree with Gabriel on this. We have to quantify the issue before we even start. At associate level, we have 5.5% of the US associates who are Black associates. It's a bit better than the average of the law firms who do report on this data, which is in the US 4.8% for the associates. But again, the situation, we do track, and we do have a policy because we want to improve that these numbers are obviously completely inadequate. So it is a pipeline issue. There are encouraging signs. You probably all have seen the fact that this year Harvard Law School had 60 Black students in the first time in the history of Harvard at the law school. I'm talking about Black JD candidates. And when I first taught at Harvard, it was in the 80s. I was very young at the time, a baby. And the debate was affirmative action, as they said at the time. You want to sort of, today we would say, proactive steps to be taken to counter this diversity issue. And it has been done, and Harvard now is a very, very different place. So it says something as to the steps which can be taken, and if you have a policy, you want to do it, it may be controversial, you have to do it, and then you change things. And you probably saw the nice pictures of these these new students and the hashtag Black at Harvard Law. But the problem really starts way before the university, because those who achieve that level will probably get very good jobs, just like their white counterparts. But how do you get enough minorities, and it's true for Hispanics and for other minorities, to get there? And it starts way before. So we do have a number of programs. We support a number of associations who focus on increasing racial diversity in the legal industry, but also at high school level, also at college level. And I want to mention two organizations who are doing a great job. It's NJ Leap and Legal Outreach. In the US, they focus on the first generation students. They are the first people in their family, in the history of their family, to study, to do long studies. And also low-income students. It's often, it goes together. And we have a week-long program. We take them, it's a partnership with Bank of America. We take them for a week. The youngsters, they spend 5 days or 4 days with us, 1 day with Bank of America, and they see all kinds of professionals doing different things, including Black partners, of course, and Black associates, and they see that we have to overcome it's not for me, I'll never get it, I'll never do it. So they have to aspire to do something important, and they don't even know where to start. They don't know it exists. And they certainly think it's not for me. So we want to overcome that. We have similar partnerships for law students with Exxon and GE. And here, the Black law students and also Hispanics do participate in a 10-week summer internship. And we do, that's prior to joining law school, and we do also programs at law school level. But that's one step, increasing the pool. Now, the other thing is when you hire. And here again, I think measurement is very important. And there is an interesting organization which is called Diversity Lab. It's a Californian organization. They measure and they provide a certification, which is the Mansfield certificate. And it's named after Arabella Mansfield, the first woman lawyer in the US. And they give you a certificate if you consider, each time you hire someone for a position of importance, you have to consider from a pool which includes at least 30% of women, attorneys of color, LGBTQ, lawyers with disabilities. So if you consider in your pool, of course, at least 30%, then you can be certified. That's also a nice and an important tool to ensure that you will consider minorities when you hire at any level, including for associates, for partners, any kind of recruitment or job opportunities or promotion. And then the last problem which we have and which we also measure is retention, because it's not good enough to hire people, then you have to keep them. And we keep track of all of that also. And it's like for women, they don't stay as long. So for some reason, they get discouraged earlier and before they are up for partnership. The statistics show a gap for women versus men, and a gap for Black lawyers against white lawyers. And so for that, we have a mentoring program. It's hard to address. You have to mentor, you have to reassure, it's a position for you, don't get discouraged, you need to have good assignments, good opportunities, and you can make it. And very important step was the creation, which has been sponsored by one of my Black partners. The Black community in the law firm created an association which is called BLAKE. It's Black Lawyers Aligned for the Quest for Excellence, because the acronym is BLAKE. But and our logo, our motto at one time was Aligned for Excellence. So we were sort of joking and said we are Black Lawyers Aligned for Excellence. And they do lots of stuff. They are extremely active. And they do lobby the firm, they lobby externally, they do all kinds of activities. They certainly mentor newcomers, and it's very important to have this sort of activity which is certainly very much encouraged and promoted in the firm, so that people feel they have a sense of belonging. Because if you are the only Black lawyer in an ocean of others, you feel isolated. So here the idea is to say, okay, we are strong enough, we can make it, it's part of the community. And again, all of that is measured. And again, I respect the French tradition, which is we don't measure, for good historic reasons, we don't want to track any of that. But at the end of the day, I think it's good to measure. And if you want improvement, that's the first step. And we are taking all these aggressive steps, I think, to change things. And I think it will happen.
Thank you. Thank you, Emmanuel, for that. Well, my next question is back to Gabrielle. Diversity deficit in international arbitration is made up of deeply entrenched historical factors that make addressing it profoundly challenging. Given ICA's global position in international arbitration, how optimistic are you that its revamped diversity and inclusion initiative will make real inroads into increasing the number of racial minorities in international arbitration?
Thank you. Personally, I'm convinced that arbitration cannot claim to be the global settlement method if it is not diverse and inclusive. But I think beyond my personal convictions, I just observe the world. You watch the trends, you watch the shift in economic, political weight on the world scene. You see increasing participation of those who were underrepresented in leadership and decision-making positions. You also see, and many have, all the speakers have insisted on this, the very strong awareness now that has arisen, unfortunately, in part through very tragic events. But what needs to be saluted is that this forces people to face the issues. So that is, so the trend to me is very clear in favor of diversity and including regional and racial diversity. Jackie has spoken about gender diversity. That is probably already a step further, but now to me, the real focus should be on regional and racial, which requires more efforts. Now, looking at the trends may, of course, not be enough. And there may be a movement, but it may be slow, and we must certainly try and accelerate it and support it. And that is the reason why ICA has not only adopted a policy of diversity and inclusiveness, but also an implementation plan. And the implementation plan looks at very concrete action that ICA can take. Now, ICA is not an institution that administers and arbitration appoints arbitrators. It's not a law firm that hires people. It is an organization that simply seeks to promote arbitration, but as part of it can do so by fostering diversity at the same time. So the implementation plan and the responsibility for this plan lies with the executive board that reports to the governing board and is advised by the inclusiveness committee. That plan addresses, first of all, outreach. ICA is committed to reaching out to relevant organizations and groups worldwide in such a fashion as to increase the diversity of its activities. And obviously, AFA is a very good example of this aspect of the activity. And then the publications are supposed to reflect an inclusive perspectives of international arbitration. That will require some work. So far, scholars and writers have rather been Western. That needs to be diversified. Recruitment and retention, as Emmanuel stressed, is also important to ICA in the sense that the idea is to continue and increase the support of young ICA. Young ICA is the future generation. That is where training is needed, where encouragement is needed. And that can also achieve an important, not only an age diversity element, which is part of diversity as well, is an important part of diversity, but obviously a regional racial diversity aspect. Accountability, I have spoken before about accountability, but the implementation plan is rather detailed on this, who bears the responsibility for what, because I am pretty convinced that otherwise that makes people feel they are in charge and they need to report to others for what they have done or not done. The idea is also to have a best practice guide that does give guidelines on how to implement the goal of diversity in terms of conferences, choice of conference venues, choice of program committees, choice of speakers. How do you go about making sure that the panel is diverse? Don't confirm anyone before you have the entirety of the speakers of the whole Congress, and then you can make sure that you have a good balance, both regional, age, gender. Working groups and project committees, of course, also need to be to reflect diverse participation. So all of this is quite a detailed plan, and I am fairly certain that if this is taken seriously, and ICA is taking it seriously, it has to show results.
Thank you very much, Gabrielle. My next question is to Jackie. Jackie, other than big law firms, chambers, and the LCA users councils, where else does the LCA source arbitrators to ensure it has a more diverse pool available to it when it has to make an arbitrator appointment involving an African party?
Yeah. Thank you, Rukia. I mean, first of all, I'd like to pick up the point other. I think what is special about the current climate, the current trend, is that it is actually by working with large firms, with chambers and users councils that we can make progress. And as Emmanuel was just saying, you know, law firms are making massive strides, and Gabrielle was describing the significant changes at ICA. So I think already working with the current providers, if you will, is helping. It's not sufficient, but it is not working against the tide, it is working with the tide. I'd also like to mention at the outset what I find really striking, and that is something which has changed noticeably in the fairly recent past, is it's not about doing something against the wishes of users. I find it very encouraging to see. I mean, just a very personal example. The other day, 2 days ago, my daughter called me up and said, "Mom, what are you doing at the LCAA to ensure racial inclusion?" This came out of the blue, and I'm very conscious that I'm a white woman and my daughter is a white girl. And she insisted on confronting me and asking me, "What do you do about this concretely?" And I could feebly say, "Well, I'm speaking at this webinar on Friday," and that got me off my back for a little while. But I think it is a good time to think about what we can do. One of the concrete, the tangible initiatives we have started to exploit in the last year or so in particular is working with very interesting organizations, slightly different organization than what Emmanuel was describing, more arbitration focused. London is in a very special position because, well, you're based here. For Africa, London is an interesting base, if you will, and a lot of practitioners come to London either to visit or sometimes to study. So it's a good starting point, and a point from where to meet many Africa related practitioners. And there is the Association of Young Arbitrators, there's ILFA, there is the African Promise, all slightly different organizations which provide a platform for providing internship, training opportunities. And as LCIA, we're very keen to work with these organizations precisely because we already have African related cases, and we see that we are underrepresented when it comes to practitioners from these jurisdictions who act as arbitrator, but who also act as counsel. So while I think it is fantastic to see that the firms based here are increasingly inclusive, it is also about reaching out to law firms in certain jurisdictions and make sure that they directly bring cases to the LCA and other institutions, rather than doing that indirectly through firms based here. Then I think the next point, which is going to be something we need to work on in the very near future, is the measurement point. And I share Emmanuel's thoughts about this. It's only been very recent that we've started recording gender. This was not something that was recorded at all when I arrived at the LCA. It was beginning, but we now structurally record gender. For other forms of inclusiveness, it is slightly more complicated. It has to be on a voluntary basis. And there are cultural sensitivities. In some jurisdictions, it is more common, more accepted to provide data. But I believe indeed that if we don't have records, if we don't have data, we cannot improve. So I will be working towards creating a better database so that we can at least see how big the problem is and how we can then start resolving it. So these are some examples of what we are currently doing, the existing organizations, which are quite arbitration focused, and then thinking about just ways to make our practices more inclusive so that we can staff our arbitrations more inclusive, but also our events. And then we get into, well, the opposite of a vicious circle. If you have more diversity sort of visibly on a panel, that will help people associate with whatever initiative it is that you're trying to present.
Thank you, Jackie, for that. My next question is to Emmanuel. Many companies now have a policy to instruct only law firms that have a diversity policy in place. Recently, over 120 law firms, including Sherman and Sterling, joined a Law Firm Antiracism Alliance. This is to promote racial equality. What would you say to a skeptic who argues that the alliance is motivated by economic and societal pressure rather than the ideology of racial equality.
Thank you, Rukia. That's a very interesting question, because it's a question which goes to the purity of the motivation. Are law firms doing it to look good, to attract clients, or to do the right thing? And it's a very hard question, because in January 2020, 125 law firms had joined this effort, the Law Firm Antiracism Alliance. And for those who have embraced this cause early, it's not a problem to join. It's not because you join that you just start tackling the problem. It's the reverse. Because you are committed to that, you can join easily. But you cannot exclude that some are doing it just to look good. I mean, who knows? So I can answer in two ways. I can answer for us. We are committed to the cause, and we have shown it. We have been representing the prosecutor in the Rwanda Genocide Tribunal for 20 years. It's not all that known because we didn't publicize it a lot, but that's a huge commitment. At times we had 2 lawyers there in Arusha for the whole period. I mean, where it was extremely active, supporting the prosecution, and that's heavy duty. Also, in terms of commitment, I can name lots of initiatives which we have taken. We have not even advertised at all. For instance, in Paris, we have been doing for 6 years programs with public schools for youngsters, because we do believe that it's at a young age that you can make a difference. Afterwards, it may be too late if they don't want to study, or they don't know that they can study, or they can do well. It's worth studying hard to do certain things which they can do just as anyone else. So we have programs. We don't go through an organization. We do it directly. We have a partnership with the lycée, or with the public school in question, and we go, we explain, we get them to understand, and we teach them how to speak. I think in many cases they don't have the codes, the social codes, how to address someone, not necessarily to discuss a legal matter, but just to explain a point, or to so it's not advocacy per se, but it's a way to express views, and we have done that for 6 years, and it has been extremely rewarding. Now, since 2018, we have also done another mentoring program where we have a team here doing mentoring for 12 young women, girls actually, from 12, 14, 15, I mean, young, and they can, it's a commitment. It's real mentorship, because they can call when they have one mentor, they can call when they have a problem of a choice, or sometimes it's family problems, whatever kind of problem they have. But it's a way to show that they can study, and we don't want to over focus on the law, so we present or what we are doing, but we also introduce them to fashion people, generally women, journalists, female executives, whatever. And we don't advocate that. It's just a cause. It's not publicity. Now, my second answer to your question, maybe for a more systemic standpoint and less personal, is that I would say, who cares? I mean, if people do if they do the right thing, their ultimate motivation, I don't care if they put a lot of time in pro bono, if they say, it's a good start. I mean, I think it's a good start if they commit, and then if they do it to look good vis-a-vis their clients, fine. I mean, it's I don't care. it will be a mixed, I think. It will, some people, it's like at church, you know, some people like to be seen giving money for the priest, and some just do it discreetly. I mean, it doesn't matter. It's I would say it's like gender diversity, and I agree that this cause has been promoted earlier and it's more advanced, but now some clients are very granular about this. They are asking us about staffing, and they track, some go as far as tracking the number of hours worked by female lawyers and by male lawyers. And it's a good discipline. And do we mind? No, we don't, because internally it's also helpful. When you staff a case, you think about it. And so it makes you be more conscious. You are, but sometimes you forget. So it's a reinforcement. So I think all of these forces are working in the same direction. And to answer your question again, in terms of minorities, in a society, at some point, different forces are pulling in the same direction, and that's when things are happening. So law firms want to do the right thing. They want to look good. Clients are going the same direction. We also have action vis-a-vis the legislature. For instance, for women, we are lobbying certain states to modify the legislation which does not want to track who is behind, you know, the minorities or women versus men. It's, for instance, in a procurement, I understand that sort of blindness of a procurement is a good idea because you want to be totally independent. But at the same time, you need to have a pool of businesses owned by women, for instance, to choose also not to discriminate. So there is a tension between not discriminating, that's the blind choice, and the educated choice. I want at least a pool of candidates who will be from, you know, more diverse in terms of gender, in terms of ethnicity, and the like. So I'm saying, I think now we are at a point where this idea is right, and a bit behind the equality in terms of gender. I think this cause of equality in terms of diversity more generally for Black, for Hispanics and other minorities is taken very seriously, and you see that the society at large is embracing that cause because it comes from different directions, and so there is no tension between one motivation and the other. They all go in the same direction.
Thank you very much for that, Emmanuel. Gabriel, my last question to you. As one of the most appointed arbitrators in investment arbitration, you must have encountered numerous situations of cultural differences between you and a party. How do you ensure that your decision is not based on a failure to understand a non-white party's culture?
It's a difficult question, Rukia. It made me think hard. Well, maybe the first thing I would like to say is that an award is based on the law and on the facts. So I've asked myself, does culture come into play here? Maybe somehow it does in the way I understand the conduct of a party, which may look different to someone from a different culture. Maybe it does sometimes in understanding the import of a national law that is not mine. But more than that, it seems to me that where culture does come into play is more in terms of procedure and how you manage a process. And because how do you ensure that participants who may come from very diverse backgrounds in terms of legal traditions and just culture generally, do find the process fair and do feel that they got their day in court. And that is, of course, important in and of itself, but for the trust in the system, but it's also important for the acceptability of the decision later on, especially if the decision were to go against a party, it must feel that it has been heard. So what solution to this? The only one I know, and I try to apply, is listen and watch. I mean, listen, and when I say listen, I mean really listen. Listening is something we never learn. We learn how to speak. Emmanuel gave an example of teaching people to speak. We're never teaching people to listen, right? So you have to listen also about what is not being said. You have to listen in between the lines of what is being said. You have to listen to counsel, you have to listen to your co-arbitrators. Sometimes you have co-arbitrators from one culture and they can be very helpful in trying to tell you, well, you know, they dissent this because you have said this and this, so maybe you can make this, you can remedy this, you can fix it by doing this and that. You can also watch, especially if you are at a hearing and you have to take procedural decisions on the spot. Watch body language, watch facial expression, watch sudden agitation among clients on one side. That gives you a lot of clues about what will be acceptable, what will be well received, and what would not, what would be considered fair or not. And that's at least the way I try to bridge these possible cultural misunderstandings.
Thank you very much for that, Gabrielle. Jackie, my third question to you. What advice would you give arbitrators of African descent to help them improve their chances of getting arbitrator appointments by the LCIA?
Thank you, Ruka. Might I begin my answer by picking up something that Gabrielle said, which, you know, we're doing this webinar online now, and what has really struck me in my teaching, which happened to be at the beginning of the crisis in March, April, is I had not met my intake of students in person, and I found it a completely different experience than teaching in person, because, and it goes in a way to Emmanuel's point about the ability to speak, the ability to persuade somebody. I found it in a way liberating that some of the biases that you are confronted with in a classroom, where if you have a greater affinity with a particular profile student, you may be more inclined to listen to them, maybe even give them higher grades. I had no idea who number so-and-so student was because I didn't see their face initially because the software wasn't yet up to speed. Now, I'm not suggesting that that's a good thing in the end at all for the reasons in a way that Gabrielle describes. You want to be alert to what is happening around you, but equally, I think this is an interesting environment to think again about what should be the way that we pick up signals coming from ourselves towards others and what we pick up from others. But now to come back to your concrete question, I think what advice I would give arbitrators of African descent is the same as every potential arbitrator. It is to engage, and it is to engage primarily with one's peers. And I started out by saying what has struck me about the cases we see coming to the LCIA, where there are African parties involved, is that it is these parties who are not appointing African arbitrators. And I think that is something that we need to work on. That means, in a way, building on the connections with law firms in Africa. And I'm delighted that the Users Council we have at the LCIA is a direct bridge to Africa itself. And previously Chief Bayo and currently Kamal Shah are extremely active in connecting with users in Africa, practitioners in Africa, and making sure that they staff cases at the LCIA in an inclusive of African practitioners profile. What I would then say is engage with your peers. I mean, there's always an idea that if you connect with mentors or people you look up to, that will help you. And I do think that is an important element. It may be inspiring to watch certain people, but I've always found also when it came to enhancing gender diversity to think about who are you working with at your level, and then build up from there. So I think engage, attend webinars, again, attend events in person, attend moot arbitrations, and just reach out to people. And I don't want to say then all will be well automatically, but I think it is people who help themselves who will then stand out from the crowd and become visible and are included into the system.
Thank you very much for that, Jackie. Last question to Emmanuel. Your firm has clients of all races. I think you probably must have answered part of this already at your first question. But naturally, clients are more likely to relate to lawyers who look like them. To what extent would you say that your arbitration practice or department is representative of the international clientele that you have?
Well, unlike the previous question on motivation, which is always challenging, this is a very easy question for us, because our arbitration department is extraordinarily diverse, and just as diverse as our client base. I mean, we have lawyers, I'm just excluding trainees, we have 34 nationalities, we have 31 languages, including Amharic. I'm not saying we are conducting arbitrations in Amharic on a daily basis, but we can speak Amharic as a group. And for the partners, they are extraordinarily diverse as well. We have Malaysian nationality, Singaporean, Colombian, Iranian, Egyptian, Australian, French, British, Swedish, and American. So it couldn't be more diverse. I know that you're going to ask, what about Sub-Saharan Africa? And we have a fantastic counsel in London. And I hope he's not listening, because he will repeat that, but no doubt he will make partner in the so a group is just as diverse as our clients. That's an easy question. Again, to analogize with gender diversity, I vividly remember a conversation I had with Michael Goldaber. He was at the lawyer at the time, and he was saying, "You have only male partners. What do you think?" I said, "It's a disgrace, but we are going to fix it." And now we have 5 female partners out of 12, with 12 male partners in the group. It's still not equal, but it's certainly a lot of progress. And I think in terms of other forms of diversity, we are also making a lot of progress. So there, that was the easy question, if any. Thank you, Rukia.
Thank you very much, Emmanuel. We're now going to invite an attendee. She's African American. Her name is Rose Ramos. She's going to give us the perspective of an African American arbitration practitioner. Rose, unmute yourself. Or do I need to unmute you?
Yeah. Good morning. Okay. Good morning, Rukia.
Hi, it's afternoon here. Are you in America?
Yes.
All right, okay.
Good morning, everyone. Thank you so much, Rukia. Thank you, Chief Bio, for inviting me to say a few words. I'm very pleased to be here. I know I don't have much time, so I will keep it very quick. The African American perspective is pretty clear in that when you look, for instance, I'll give an example. When you have a student in Africa itself assuming such student after graduation knock on Chief Law Firm door and ask for a job or ask Dr. Baruti for a job in Africa, and if they don't hire that student, it's never because they are Black, because Africa is a Black, it's a Black continent. You have Black president, Black everything. So if you don't get hired, it's maybe for a different reason. But the reality for African American, and unlike what Professor Gaillard mentioned, I have Harvard graduate and Yale. It doesn't matter where you graduated from. Your color is your passport. And if you have a name such as James Smith, maybe the employer think that you're white. And when you get to the door for the interview, they say, oh my God, you're Black. Your interview happened differently and you never get a call back. It's the reality for African American. And to put it in perspective with George Floyd, when we all watched him die, and I think it did something on all of us. We all become somewhat humanitarian because when we go to the movies, we see something like that. We know it's fake, but that was real. And I would say that African American have dealt with a systematic denial of wealth, opportunity, education, and you name it. Yes, Harvard now is taking, I don't know how many, but the problem is there inclusion? That's the big deal. In the words of Lucy, I believe Lucy Rood, as she says, currently attended a webinar, she says that the diversity is when you invite me to come to the party. So now that I'm at the party, and since I've been excluded for over 400 plus something years, maybe I don't feel comfortable. I'm still sitting in the back of the bus. But now inclusion is when they play the music, invite me to dance. So that resonates with me. What are the law firms doing to really include these individuals? For sure. And we can say that, and I'm going in context, Dr. Baruti, recently on June 22nd, the American Bar Association published a report based on a study that's been conducted. They have looked at 20 years span. And just like Professor Gaillard mentioned, yes, indeed, the women are leaving. But we have to ask ourselves why the women are leaving. It's not just that they get discouraged. And I had brought slides. We don't have time to go through it, but I will try my best to tell you some of the reason why women are leaving these firms. It's because they don't get the support, they don't get the mentors, they don't get, they are like a Black woman, for instance. The fact that she's speaking out, she's told that she's too vocal, she's too Black, and what do we have in our firm inside to come? Is there a standard operating procedure to allow us to retain these practitioners? Because the ABA says 70% of Black women and Hispanics leave the firm. And they look in the span of 20 years and they saw only 2% made partners. So we're talking about in America in itself. And last, I would say that when we see international arbitration, and that's what Dr. Simpson and Nancy Tevenin, Nancy is also African-American, and they came and they did this research together, and they have published, and I have the report. If Dr. Baruti would give me access, I could show it. When you look at the law firm, she looks exactly at just international arbitration. not globally, just that niche area. You see, they have about, for instance, Baker McKenzie, 252 lawyers, 0 Africans. And she looked at worldwide. And for Professor Gaillard, I think his firm has about 67, 2. Lando, we know from London, and another African-American in Washington, D.C. Now, the reports goes on, and we have and we look at those reports and we say to ourselves, what's going on? And when the Jay-Z case happened, like Dr. Bauti mentioned, the AAA says we only have 2 African-American potential arbitrators. Now, I beg to differ. I guess my name was not on the list. I can count, we have more, but the issue is, do we engage them? Do we give them that opportunity? And the African-American arbitrator is still a unicorn. We can't say that for Africa, because now I have Chief Bayo, I have Dr. Bauti, I have Babajide, I have Dr. Emilia. I can go on. And I love them all. I work with them. And so they're doing great work, but the African American is still left behind. So the issue is, what are we doing to include them? Because they are there. So I'll stop there, Dr. Bauti, if you have any questions for me.
Thank you. Thank you very much, Rose. I'm going to invite the panelists. Chief, you're also free to comment or say anything that you wish to say. Does anybody have a comment from the panel?
Yes, to start, because I was overly optimistic. My take was that when you go to prestigious law schools, you made it, right? And then you have good jobs and a good career. And now Rose is saying that it's still difficult afterwards. And I like the analogy, you go to you're invited to the party, and now you have to be invited to dance. And it means I have been maybe a bit overly optimistic. So it means there is a lot more than I thought to be done. I still believe that starting early and enlarging the pool of talent and encouraging people to go to law schools or medical schools or whatever long studies, as opposed to finding a job immediately, is important. But you say it's equally important to continue to mentor minority lawyers, because they may feel that they are not invited to the party. We certainly try to make sure they go see clients. We appointed in 2018 a chief of diversity for the first time in the history of Sherman & Sterling, in charge of that problem, just to follow, to track, to make sure, to mentor, to make sure that nobody is too busy to forget about this type of issue, that we still have time available when people need to talk to us. But I respect what you say. I mean, it's still a problem, and it shouldn't be. So there is a lot of work to be done, and we just need to do more.
I'm happy to chip in if I may, Rukia. I think it's Rose, what you say sounds so real, and I think with gender diversity, similarly, there was initially thinking, well, as long as enough women enter schools, law firms, then all will be well automatically. It's just a matter of time and it will be resolved. And that's just not the case. And what is especially disturbing is that with gender, arguably, there were certain career choices where women might pull out at a certain age because of family reasons, whatever. I'm not saying that it's how it should be, but I could to some extent see why the retention problem was a problem for women. And when it comes to racial diversity, I do not see why retention should be such an issue. But I understand that indeed, as you say, that is the true problem. And that's why something like the race fairness commitment is interesting, because what they force law firms to do is not focus so much on hiring, but they focus on career progression once people enter a law firm. And I think that's where the focus needs to be.
Dr. Bauti, may I?
Yes, please, go ahead.
Yes. I think both of you are correct. And I think the one thing we must also remember is that African Americans, when they graduate law school here, we see a lot of them become criminal defense lawyer, they become family lawyer, they do a lot of domestics, and they are not really given the opportunity to be, to practice international law. And I can also speak from experience, born and raised in Haiti, and came to America, did my entire studies, moved to France, practiced in Paris, but I never get an opportunity to be in the big firm. Blessing in disguise, whatever that is. But the bottom line is, we can say that one needs to continue forging its own way. And African Americans, they have done that. They've gone to the schooling, they've done everything, but yet they are denied certain opportunities. And just like the ABA report says, the female lawyers who remain in the profession, because they are so resilient, they refuse to give up and they continue pressing forward. And I think if we just like Professor Gaillard says, if we start from the bottom, the counseling, the mentorship, from high school going up, maybe we can get somewhere. Maybe in 20 years time, I won't have to watch a webinar where my daughter, who just graduated from Wellesley College, okay, would be sitting and having the same conversation with your grandchildren or your children. And that's the goal, I think. And we cannot fix what happened overnight, but we can take steps from this day forward. From now, what do we do? And I think webinars such as this one would help. The uncomfortable communication will help. And if you look at the chart, unfortunately, Dr. Bauti, I can't show the chart, but if I could.
Aren't you able to share? I allowed panelists to share.
Oh, you did? Okay. Professor Gaillard's law firm is not the worst. It's not a critique, because the law firm itself, who represented Jay-Z, has no black lawyers, and they were the one who pulled the black card. 76 lawyers, there was none. Let me see, share screen. Okay, all right. Let me see if I could find it here. Maybe when someone else starts speaking, I'll look for it, because I had it up in my screen where I'm, okay, there we go. Let me see if I can share screen. And yeah, Professor Gaillard would see, and I'm going to, okay, great. Now, let me go straight down. I call it the report card, okay? So, let's see here. I don't know if you can, okay, great. All right. If you see here, Double Voice has about 29 lawyers. They have 3 African Americans. Freshfield has 42, 0. King Spalding, 121, 2. And you can go down, let's go for the big numbers. Jones Day has 252, only 2. We're talking just international arbitration. And then you go Mayor Brown, 576, only 5 African Americans. And I think, and I love the study that Dr. Simpson did, and it really put it in front of us. It really makes us, and like Professor Gaillard says, maybe in France, for cultural reason, we don't like to check and get these things. But when we have the facts in front of our face, then we start being conscious about our hiring strategies, because the Black talents are there. They are there, and they are getting discouraged. They're becoming a skeptic. Why should I apply? I'm never gonna get the interview. Or why should I apply? I'm never gonna get a call back. And that's what we need to look at. Yeah, we can give a lot of money to different organizations. We can do all that, but at the end of the day now, are we going to invite them to the party? Are we going to have a standard operating procedure to help them inside the firm to stay? Because trust me, a lot of women call me and they're asking me, Rose, can you mentor me? Can you do this? And I said, okay, I'll mentor you. But if I don't have the way to get them somewhere, they really cannot advance. But if we have real mentors with connections and opportunity, maybe we'll get somewhere. And I think what Professor Gaillard mentions, to start from high school and start mentoring, it's a great initiative, and it's a right step, you know, it's a first step in the right direction. And we need to do that. Otherwise, African American and Hispanics are leaving the profession.
Thank you, Rose. Are you done with the sharing of the screen?
Yes, I'm taking it off now. Sorry, right. I am technology. Okay, good. Okay, good.
Go ahead, Bio.
Okay. I just want to underscore the point made by Gabrielle when she was making her contribution concerning cultural issues in arbitration and consulting a co-arbitrator to resolve such an issue. And to say that that makes it important to ensure that when you have disputes that involve African parties and any other conglomerate internationally, it's important to have at least one African arbitrator on the panel. Because if you don't, there'll be nobody to consult. And I had that personal experience in arbitration in the UK between an African party and an international conglomerate, where a very, very serious cultural issue came up. And if not that I was a member of the panel, it would have bungled the whole hearing. But luckily, because I was there, I was a co-arbitrator, and the presiding arbitrator, I don't want to discuss the details because it's confidential, but the presiding actually now consulted me, and I gave an answer to not the cultural issue, which saved the day at the end of the day. So it's very important when you have, I mean, granted that African parties do appoint their own co-arbitrator, but if there are two co-arbitrators and one of them is an African, for an African dispute, it's always important to make the chair an African, so that if such issues do arise, then it can be resolved. Thank you.
Thank you for that, Bio. Does anybody else want to say anything before we start answering questions on the Q&A?
No, can I just say, Rukia, it was very interesting to hear you, Rose, and it was very sobering somehow. What you're saying, I mean, you have figures, but it's also more in terms of testimony and your personal experience. And it just shows once more that we're right trying to do our best here. It is really needed. So thank you for your contribution.
I would say that I was recently interviewed by Arbitral Women, and you can read the recent interview on my parcours. So it's an interesting read. So Dr. Bawuti, I invite you to read it as well. Thank you.
Right, we're going to start taking questions, and the first question I see here is from Abu Bakar 4. I think it's addressed to Ika, so that's you, Gabrielle. It says, does ICA have a policy to promote arbitration in Africa, in particular towards African judges, to help them understand their role in supporting the arbitration system?
Yes, ICA has an African arbitration practice group that does cooperate with AFA and works on African projects. In terms of judges and making judges more familiar with arbitration, including about enforcement of award, but not only. It has a special group that is the Judiciary Committee. It has just recently approved to a new project that is sponsored by Judge Yusuf about gathering a database of African decisions on arbitration that go relatively far back, because there is apparently a lack of knowledge about African judicial decisions in respect of arbitrations, that may be judicial or not. And so this is just starting now, but has just been approved, and that is also a way of contributing to promoting arbitration in Africa. Absolutely.
Thank you very much, Gabrielle. The next question is not specifically addressed to anybody. It says, this is from Chizaram Uzodinma. International arbitration practice is generally seen as a difficult circle to break into, especially for newcomers. Considering that Africa is relatively new compared to its Western counterparts in the business, do you think that this poses a hindrance to the diversity movement? Anybody?
I'm happy to start. Some of the initiatives which I mentioned are directed primarily at young African practitioners, and I think it is a good example where by focusing on one variety of diversity, you can at the same time tackle another form of diversity, because there's also an outcry, understandably, that in arbitration there is potentially too much scope for too senior practitioners, and I find it encouraging to see people engage actively with their peers, and where you see initiatives supported by law firms and supported by more senior practitioners, but where you see younger practitioners teaming up, I think that is likely to succeed. And it's encouraging to see that the African community in London seems to be quite effective, even compared to non-African initiatives. So to me, that suggests that there's hope there.
Thank you. There's actually a question directly to the LCAA, which is from Joyce Olwach. I hope she's still around. She said that she was about to leave. She says, how do non-African parties in arbitration usually react when the arbitrator chosen by the LCAA is African? And does this happen often? She wants to know how non-African parties in the LCAA react when an arbitrator is African.
I understand the question. It is not something where I have data. I would not have any reason to think that the reaction is any different than when the LCIA selects an arbitrator who's African or non-African. I think that's the beauty of institutional appointments, that people can rely on the institution doing due diligence when it comes to an arbitrator's independence, impartiality, and availability. And hopefully can do a good job at sourcing potential new arbitrators. I have nothing, no evidence to support that, but I don't think that there are any issues there. I think where there are issues is the flip side, where I see African parties not selecting African arbitrators, and that I genuinely do not understand.
I think there's one question here for Emmanuel. It is from Paul. Sorry, I cannot pronounce your second name. It says, is the gap not a symptom of toxicity associated with institutional racism? I think you were referring to a gap earlier on when you were speaking, Emmanuel. Do you see that question?
No, I'm sorry. Can you repeat the question? Because
he says, is the gap that you're referring to not a symptom of toxicity associated with institutional racism? So,
there may there may be, I think it's like what Rose said, there may be barriers, and one way to deal with it is to fight for your own cause. And to answer also with that question, one of the previous questions, as to the appointment of African arbitrators, it's for the clients to control the case. It goes for the applicable law. It goes for the choice of law firms. And if they just delegate to the law firm the work and say, okay, it's an arbitration in London, you guys use an English law firm and they do it their own way, it's not going to change. Because it's not that they are racist or they have barriers. It's just that they don't know the community. They don't know where to start. They don't know the good arbitrator, the African arbitrator who would do a great job. And last 10 days ago, we had my first non-virtual hearing. It was partially virtual between Paris and Douala. It was half of the team in Douala, half of the team in Paris. So it was virtual to that. In that we didn't travel, but we were physically in two different rooms connected by video, and it was a case in which the arbitrator was African, but the party was represented by an African law firm. So they know the community better. It may be a better choice, and I have to tell you, he did a great job. So, but I'm not sure, that the other big law firms would be equally equipped to identify the right arbitrator to appoint in a case. And I think it will change for one reason, because we will see in Africa, like we have seen in Asia a bit earlier, big local powerhouses in terms of arbitration. And when the clients will choose these lawyers, they will in turn choose the right arbitrators, because the institutions comes too late. They choose in very, very a few cases because the chair is chosen by consent. So we have to start with the appointment at the level of party-appointed arbitrators. And I think things are going to change. But for that, the clients themselves have to take an active role and not delegate the strategy and everything, all the choices, including the choice of the arbitrator, to their law firm. That's not just good enough.
Thank you. Thank you for that, Emmanuel. Is there a particular question any panelists would like to answer from the ones that you can see on there? In the meantime, I think I will answer this. I think I see two questions to the AFA. The first one says, how can the AFA pioneer the inclusion of succession planning? This is from Ekuchukundechu in the curriculum for mandatory continuing professional development for African practitioners in Africa. Well, with regards to continuing development, professional development, the AFA or the AFA is not really involved in training. So what it intends to do and plans to do is to work with institutions within Africa that are already training the African practitioners in arbitration, like the Chartered Institute or any such institutions, and using also the members of the AFA to participate in the training. That's the answer to that, Akuchukwu. I hope that's sufficient for you. In the meantime, have you decided what you want to answer, any of the other panelists? I think we have 5 more minutes. We can answer one question each, and we'll have to then end the webinar. Bio? No? Okay. I see a question here from, I think this will be to the LCAA, from James Clancy. He says, can institutions do more to appoint African arbitrators in non-Africa related arbitration, i.e. European arbitrators are frequently appointed in cases having no connection with Europe, thereby boosting their profiles internationally. So can we do the opposite?
I think we can, and I think that's actually what we are seeing in cases. If you look at the number of cases where the contracts are not governed by, where the contracts are governed by English law, and we still, as LCIA, managed to select African arbitrators, I think it clearly demonstrates that we are working on this. We need to do more, and it's about building the connections, as I said, through the users' councils, by picking up Emmanuel's point, reaching out to local practitioners, reaching out to the actual users, the actual clients, and that is through institutions such as the users' councils. Yes, more can be done, but that is not a specific African issue. It is definitely an issue for African practitioners, but I think it is it's something that is very much on our mind.
Thank you for that, Jackie. There is one question for Emmanuel here that I see. It's relating to the, I think it's Emmanuel, International Arbitration Institute. Is that you? The Paris one? You will need to unmute yourself. I don't think Emmanuel can hear me right now.
Yes, I can, but
Okay.
I could not unmute because I was looking at the questions at the same time. Sorry.
All right, okay.
Yeah, but okay. Yes, it's me. I chair the Arbitration Institute. Yeah.
So it's asking whether your institute plans to partner with AFA like us or any other Africa-based institution to organize conferences or seminars or such sessions.
Yes, we have always made a conscious effort to invite African arbitrators to be listed in the institute, because that was one of the first. Now there are several instruments, but it was one of the first way to get on the database of potential arbitrators. And it's extremely important to be considered when people look at whom am I going to appoint, to know what their skills are, to know see the resume, to do a research and so on. So we certainly welcome all the initiatives to have more African arbitrators and listed. So any partnership is welcome, and we have done a lot of things to that effect, but more can be done, and we are happy to receive any suggestion.
That's great. Gabrielle, do you want to answer one last question?
Yes, sure.
I don't know which one would be most suitable. Do you see one that you prefer to answer?
I cannot read because I'm not familiar with my
Oh, you can't read
yet, but I will, after this, I will fix it.
Okay,
I realize that I don't know how to look at the questions, which I can do with my laptop, but here I don't have my laptop. So you pick it for me. Okay,
the one that I see that you may be able to answer, but I don't know, is directed to resources like CLUAR publications and such. It says, can research resources be made more affordable for African arbitrators? Resources such as CLUAR are almost unaffordable for young African arbitrators, and these are one of the next generation for Africa.
Yeah, absolutely. I think it's an important point in the sense that more and more is actually now published with open access. I published a book 2 weeks ago, and we made an arrangement with the publisher, so it's open access precisely because of this, in recognition that the resources may be quite expensive, but it's obvious that more needs to be done on this. a lot of resources on the ICA website are free. All the reports of ICA committees and task forces are free access, but others are not, and that is certainly something that needs to be worked on. Fully agree with that. Yeah.
Thank you. The last question we'll take, Chief Bayo is going to answer. That is to the AFA. It's asking, what is the AFA doing to promote the appointment of African counsel and African arbitrators? This is from Funke Adekoya, to potential international disputes within their own country.
Yeah, thank you. At the last conference we had in Kigali, we actually had discussion on this particular topic. And we decided that, look, the various ministries of justice, legal officers, solicitor generals are the ones who need to make these nominations. In the past, the issue was lack of capacity. But over the years, we've had lots of notable arbitrators coming out of Africa now. So we'll continue to engage in that advocacy and ensure that this is done and the situation would improve.
Thank you. Thank you for that, Bayo. And I'm going to thank everybody for joining this webinar. Thank you very much to the panelists for their contributions. And it's been an enthusiastic participation. There's so many questions. I'm pleased to see that people actually did submit questions. And I just wish you all a very good afternoon for the rest of the afternoon that's remaining. Thank you. And
thank you.
bye.
Thank you. Goodbye.
Thank you.
Bye-bye.
Thank you. Goodbye, Rika.
Thank you,
Goodbye,
Dr.
everybody.
Maliki.
Bye-bye.